Welcome to the Thomson Reuters webinar on Consumers' Rights Act 2015. Thanks for tuning in. I'm Cho Mwigwe. I'm the in-house new business sales manager here at Thomson Reuters, and I'm here with my colleague, Rachel Wyatt. Say hi, Rachel.
Hello there, hi.
Rachel is a commercial editor here and originally trained at Fox Williams. Her last role was in the commercial IP and IT department at Bristow's, where she spent 11 years. It's good to have you here, Rachel. How are you?
I'm very well, thank you.
Excellent. We're all looking forward to hearing your answers to the coming questions. Okay, so the setup of the webinar is I'll be putting to Rachel the most frequently asked questions submitted by Practical Law subscribers. She will also answer questions from registered users sent over the past few days, and depending on how much time we have left, she'll go through a few questions that have been submitted live during the course of this webinar. The session will be approximately 45 minutes, and should you wish to submit a question, you can do so via the Q&A box, which will follow up with you individually if we do not get a chance to answer them within the time we have. Also, if you're experiencing any technical difficulties, you can use the Q&A box to alert us of that, and hopefully we can help you out. Okay, so we'll also be recording the webinar and sharing it afterwards. Cool. So, on to the webinar itself. Rachel, are you ready?
I'm ready.
Excellent. So let's jump straight into the first question. Which is, we supply primarily services, broadband, but also goods, such as routers, under the same contract. What happens if the routers are defective? Can the consumer also terminate the services element?
Well, the position under the Consumer Rights Act is that it's bringing together the rules on goods, services and digital content into a single piece of legislation, but it still treats each element distinctly. So in this scenario, you've got a router, which is goods, and that's the thing that's defective. So the consumer would have a short-term right to reject. Then they'd have to accept one attempt at repair or replacement. And then if that doesn't work, they'd move to the final right to reject or to receive a price reduction. But as to the services, in this scenario, they're not actually defective. There's nothing wrong with them. It's just that you can't access them because of your router. So you don't have a remedy for the services, which seems like a poor situation for the consumer. But whilst you've got your statutory rights, you've still got your common law rights. And so you would still, the consumer would still have a right to claim damages in respect of the defective router. And that could include like the cost of the broadband that the consumer was unable to use and sort of potentially other losses as well. So I think in terms of an action point for the supplier, you need to sort of be fully aware of all your customers' legal rights and use that to inform your customer care policies. But I think in practice, most businesses would probably refund the broadband for a period it couldn't be used, where the router was the cause of that.
Super. Thank you, Rachel. Okay, so we're going to move on to the next question sent by one of our subscribers. And that is, we sell tiles for indoor flooring online. We sometimes get emails asking about suitability for their use outdoors. Are we at risk if we do not respond promptly?
Well, it's always been the case that goods must be fit for a purpose made known to the trader. And the Consumer Rights Act has introduced a small change because it says that the consumer must give the notification before the contract's made. So clearly that's a slight improvement for the trader. I think in practice, the questions that people are facing are, if you're selling online and the consumer emails you immediately before pressing the purchase button, saying that they want to use it outdoors, have they made known their purpose to you, and are you then fixed with that? And the BIS guidance, the government guidance, does address this, and it says, no, an email immediately before purchase probably doesn't count. But if you've engaged with the consumer in some kind of email discussion, then you probably are treated as knowing what their purpose is. And I think it's interesting in this because there's a sort of parallel situation in the context of delivery, because there are new rules on delivery introduced by the Consumer Rights Directive. And they say that if before the contract was made, the consumer told the trader that delivery by a particular date was essential, then if the trader misses that date, the consumer has an immediate right to terminate. So a similar situation could arise immediately before buying. The consumer could email the trader and say, well, I definitely need it by next Monday, and otherwise I don't want it. That's essential. Would the trader then have to meet that delivery date or face having to refund? And I think it must be the case that similar a similar rule applies, that you can't just send an email and then buy and expect the consumer to comply with what you've asked for. But I think in terms of action points for the trader, it's always a good idea to have an automatic response on your email addresses and your customer helplines saying that you'll reply within so many business hours to give you a bit more leeway. And also, in your terms and conditions, you should make it clear to the consumer that they're placing the orders, they're not forming the contract. No contract's formed until you actually accept their order, which is what most people do in any case.
Superb. Thank you, Rachel. Off to a good start. Ready for the next question?
Yeah.
Superb. Okay. So our products have complex pricing structures. How do we ensure all pricing and other core terms are sufficiently prominent to be exempt from the fairness requirement?
Yeah, so under the Consumer Rights Act, almost all terms of a consumer contract are assessable for fairness, but core terms can't be assessed in that way, and the core terms are those which specify the main subject matter of the contract and those which go to the adequacy of the price, so the amount paid can't be assessed for fairness, and that was the law previously before the Consumer Rights Act. But what has changed is that, as before, core terms are only exempt from the fairness assessment if they're transparent, and that already means easy to understand. But the UK government chose to introduce a new requirement that the terms have to be prominent, and that can cause some concern where a trader is seeking to make a lot of complicated pricing terms exempt from fairness. And there is some very useful guidance which has been issued by the Competition and Markets Authority on the unfair terms provisions in the Consumer Rights Act. And they have a whole section on prominence, this new requirement. And what they say is that, well, the legislation says that to be prominent, a term must be brought to the consumer's attention in such a way that an average consumer would be aware of it. And then the CMA guidance says that what they're going to do is they're going to look at the content of the terms and conditions, how it was communicated, its structure and its length. It will also be relevant what the trader and its representatives say during the sale process. And also they're going to look at advertising material. So to bring that to some concrete suggestions, what they say is try and use key facts and other summaries. And they also say that differing levels of prominence, they anticipate differing levels of prominence. So the most onerous or unusual terms, and the example they give are terms under which you have to pay a sum of money, but it's not entirely clear whether on something happening you have to pay a sum of money, but when you're entering into the contract that seems unlikely, or it's a remote or unclear possibility. Something like that they treat as an onerous or unusual term, and that needs the most prominence. But what they go on to say is that they don't think that prominence will always be possible for all core terms, particularly if there are numerous charges for various services, some of which will or might arise depending on what the consumer chooses and external factors. And also they say that you need to be to try different approaches, because a single approach to highlighting won't be effective if you use it on all the terms. It can only be used on isolated terms. And the goal is to make sure that consumers understand the essential features of the bargain that they're entering into, and that they can compare and decide between different products. And I think also in this context, it's interesting to note that the government department, is also currently consulting on whether to mandate further measures to improve consumer terms and conditions. They've got an online consultation running which closes in April, and they're asking for responses about things like having auto-opening of terms online, using a simple index, key fact sheets again, shortening terms, grouping them under clear headings, and also separating negotiable and mandatory terms. And I think the other sort of area to look at is the Financial Conduct Authority, because they've done quite a lot of work on consumer terms and conditions in the financial context. And they've also got a sort of web page which discusses options, and they talk about things like having videos, and they've got some examples that people have used, and using diagrams and tables. So I think it's definitely an area to watch. There's obviously a concern that the consumer terms and conditions aren't sufficiently clear and generally, but also these suggestions could help you achieve prominence for your core terms.
Excellent. Very in-depth answer there, Rachel. Thank you. So we'll move on to the next question. So, would customers who own cars affected by the toxic emissions scandal have the right to reject their vehicles under the new law? And what is the effect of a fix not being available yet?
Well, I think the consumer will have a right to reject if they can establish that the problem with the emissions results in the car not conforming to contract. And I think, obviously, that's the first question. I think there are three grounds on which you could approach this. You could say, we don't think the car is satisfactory quality, and that really is the car fits the purpose for which cars are generally used. And obviously, it's a question of degree, but safety is taken into account in assessing satisfactory quality. So I suppose you have to ask whether high levels of toxic emissions make the cars unsafe. The other thing to look at is, does the car match its description? Because that's the statutory term, as it must. And then you need to look at, the marketing literature. Does that specify the level of toxic emissions, or say that the car had passed the test? And if it did, the trader could be in breach. And then also there's the requirement that the trader must tell the consumer about the main characteristics of the products. And that main characteristics is a term from EU legislation, and it's previously been defined to include things like risks and results to be expected from use and details of tests or checks carried out on the product. So there seems to be an argument possibly that the trader should have told the consumer about this, even if it didn't, it should have done. So it will be in breach by not telling them. And obviously if it did tell them and it doesn't match up to those characteristics, then he's in breach as well. So assuming that the consumer can prove that the high emissions make the car defective, they've got two rights to reject. The first one is the short-term right to reject, which expires after 30 days. So if the 30 days is gone, they can exercise the second final right to reject, but before they do that, they have to give the trader a chance to repair. But the repairs have to be done within a reasonable time and without significant inconvenience to the consumer. So I think in this car example, the manufacturers are saying, well, we're going to roll it out over the next couple of years. Could you then claim, oh, well, that's unreasonable, I want to be able to reject it straight away instead? But this gives guidance on what's reasonable. Say you need to consider things like the impact on health or safety, which I think could be difficult to establish. You have to consider things like whether the consumer is suffering a financial loss. I suppose you could say, if I won't be able to resell my car until it's fixed. Also, you consider whether the consumer's got access to an alternative or a temporary replacement, which I don't think is relevant here because they can still drive the car. So you may conceivably successfully argue that you don't need to wait for a repair, so then you would go to the final right to reject. But you need to remember that the trader can make a reduction to reflect the value, to reflect the period of use you've had of the car. So if you've had it for a few years already, you're not going to get the full, well, for whatever period they can make a reduction. But the longer you've had it, the bigger the deduction rather. But the clarity that's come in this deductions of use thing is that it's not just, they can't just give you the second-hand value of the car at today's date. It's more about prorating the price over the anticipated lifetime of the car. So it's slightly better for the consumer.
Oh, thank you, Rachel. Okay, so short question for you this time around. Does the consumer have to return faulty goods?
There's a short answer as well. It's, no, they don't have to, which is why they don't have to as a default situation unless you put them under a contractual obligation to do so, which is obviously what you should then do. But so you put your contract term you put the obligation to return into your contract, and you put it ideally into the pre-contract information as well. But even though the consumer has to send it back, you still have to pay the cost of return because we are talking about faulty goods. And I think as a matter of practice, you'd need to sort of think about either offering a free returns label or position slightly different where the goods can't be posted. You could, I think if you impose a term on them saying that they've got to send them back, even when there's something that can't be posted, there's a risk that that could be treated as unfair. And I think because you're having to pay the cost of return anyway, it's probably to your advantage if you arrange for them to be collected by your delivery people or collection people, because then that's the way you retain control over costs. So, yeah, that's the position.
Okay, super. Thank you. Okay, so from a short question to a longer question for you, just bear with me while I read through this. So, under the CRA 2015 is the right to reject effective if the customer got a faulty washing machine repaired by a third party not connected with the retailer, and the repair did not work. Would it be different if the retailer gave the consumer the money for the repair by the third party, and the consumer is now outside the 30 days from purchase and is trying to reject the washing machine?
Okay. I think the first question is, did the seller effectively sanction the repair? Because the seller doesn't have to do the repair itself. It can subcontract it to a third party. So are you in a situation where the consumer could argue that the third party was repairing on the seller's behalf? And I think if the seller then refunded the price of the repair by somebody else, you're kind of drifting into that territory. I suppose you also might want to look at the timing, because if the consumer had the third party repair it before they then complain to you, it's harder for them to argue that the third party was doing it on their behalf. But, so if the third party was on behalf of the seller, then the 30-day period might not have expired, because it goes on hold from the point that they request or agree to a repair until the time they get the goods back. And if they request the repair on the last day of the 30-day period, they still have 7 days from the day they get it back to exercise the short-term right to reject. But assuming that it wasn't done on behalf of the third party, wasn't acting on behalf of the seller, then the 30-day right to reject will have expired. And the consumer can't just say, oh, I want to reject it. They have to allow you to repair or replace it before they move to the final right to reject. And I think in this scenario, as a trader, you might want to look at whether you could argue that the third party has in fact caused the defect or made it worse. In this scenario, from the first 6 months, there's a presumption that any defects present on delivery, but obviously that can be rebutted by the seller, adducing appropriate evidence. So I think my action points on that one were just make sure that your complaints and return policies reflect the new law, and also it's perhaps an argument for setting out the consumer's rights and remedies clearly so that they don't start making inappropriate claims.
Superb. Thank you. All right. So moving on to the next question sent in by one of our subscribers, and one that I'm quite keen to know the answer to, actually, is my mobile phone insurer says that any repairs are only guaranteed for 6 months. Can they do this?
Oh, well, insurance is a service, and it is in scope for the Consumer Rights Act quality standards. It was previously governed by the Supply of Goods and Services Act. So the standards for services are the services have to comply with any information given pre-contract under the Consumer Contracts Regulations. That would be about the main characteristics of the services. And then also have to comply with any information voluntarily provided by the trader and relied on by the consumer. So I think the first thing to do as a consumer in that situation is to check through the marketing materials. And is there anything which suggests that repairs will last for longer? Any broad statement that you could point to that suggests that you would be enjoying the benefits for longer? But you need to bear in mind that the trader can qualify any statements that it makes. That's provided for in the legislation. So you have to check the caveats to the general statements as well. And it's for the consumer to prove that you gave the certain information, that they relied on it, so they've got to bring it forward and show it to you. The other test of service is the old one, that they must be provided with reasonable skill and care. So it's about how the service has been carried out, not the end result. And that, when the Consumer Rights Act was going through Parliament, there was a push to move to more outcome-based standards where you looked at what the trader had actually done, not how they'd done it. But the government said that was too subjective and they rejected that. So what would amount to reasonable skill and care in this scenario? You have to look at basically industry standards and code of practice and things like the price paid for the service. What can you reasonably expect is effectively the test. And I think perhaps a blanket statement that nothing will last for more than 6 months might be inappropriate, because it might depend on the type of repair that you're doing. Some might last longer and some might not. So if you succeed in showing that they haven't exercised reasonable skill and care, then your remedy is to have it done, the service repeated, so get it fixed again, or to get some money back. And I think from the insurer's point of view, obviously they need to sort of consider their industry standards and perhaps consider whether a blanket statement is appropriate, and also review their marketing material and make sure there's no sort of broad, extravagant statements, or that if they are, they're to be caveated.
Okay, thank you. Very insightful. Next question we have is, we are a dry cleaning business and want to limit our liability to £200 per transaction. Is this possible under the CRA?
Well, the Consumer Rights Act has introduced new statutory remedies for services, and new controls on the extent to which a service provider can limit its liability for services. So what it says is that you can't cap your liability below the price of the service, and even if you do cap it at the price, that's subject to the fairness test. And the Competition and Markets Authority advice in their guidance on unfair terms, they say a provision restricting normal damages, so basically any cap, would be under strong suspicion of unfairness. So I think that kind of slightly raises the question of whether there's any value in having a cap, because it's not to your advantage to have terms which are unenforceable. You know, you may be subject to trading standards scrutiny. So consider whether your limitations are fair and enforceable. I think you look at the other protections which you can have, so things like insurance, and also providing pre-contract information about any inherent limitations for the service. So, for example, like particular fabrics shrink, or whatever might go wrong, I suppose.
Yeah.
Yeah.
Okay, thank you. All right, so the next question then from one of our subscribers. Given that it is now a term of the contract that digital content must match its description, and any changes to the description must be agreed with the customer, how do we deal with updates?
Okay, so the Consumer Rights Act envisages suppliers updating digital content, and it says that they can do that where they've reserved the right to do it in the contract. But it says that the updated digital content must continue to do what it's described as doing in the original product description. So that's one aspect of it. You need to reserve the right to make changes in your contracts. But you also need to consider the CMA guidance on variations. And what they say is that the key thing is to give consumers as much information as possible about what changes are anticipated and their effect. So whenever you're reserving a right to change what you're supplying, whether it be digital content or something else, you need to make it clear to the consumer what kind of changes you're going to make and how that might affect them. And definitely the best place to do that is in the product description, which is where the consumers may actually read it. Some key suggestions from the BIS guidance for digital content are: consider stating that the digital content will comply with the latest and previous version of the operating system, so don't tie it to a particular one, make it clear that you're going to update it. Consider describing functionality in technology-neutral ways. So, for example, don't say that it's going to have a particular spell checker, just say it's going to have a spell checker, don't say it's going to have a particular type of spell checker. And you also need to consider whether you might want to remove unused features, and if you are going to, then you need to flag this in the pre-contract information. The other point to remember is that new features don't form part of the description, so there's perhaps more leeway to remove or modify those, although the fairness aspect still needs to be considered. And also, 6 years from supplier is the cut-off period. So after 6 years, no claims may be made. I think the position is, it's only not from the date of the update, but from the date of the original supply. So I think the advice to the suppliers is to make sure that you review your marketing materials and you're ticking all the boxes and look at the CMA guidance, because it's very useful, and the BIS government guidance on updates to software.
Okay, super. Thank you. I hope that was useful to whoever sent that question in. Thank you. Next question, which I believe may be our last. We host a website from which consumers can download, free of charge, an app to help them design their kitchen. Does the app have to meet the quality standards?
Well, the position is that the app's not being paid for with money or bundled with paid-for items. So the new requirements for satisfactory quality, compliance with description, etc., introduced in respect of digital content don't apply. But the Consumer Rights Act does give a remedy where the digital content supplies under a contract. So it just needs to be a contract. You need to have consideration, but it need not be money. So in this free app scenario, if you're making them accept, the consumer accept terms and conditions, then the very fact that they're accepting restrictions or perhaps providing personal data, that's sufficient consideration. So there'll be a contract in place. So you've met the first requirement. And then the liability will follow if the digital content that you're then providing causes damage either to a device owned by the consumer or to other digital content owned by the consumer. But you'll only be liable if the damage is of a kind that wouldn't have occurred if they'd used reasonable skill and care. So it's not strict liability, it's a sort of reasonable skill and care test. And they say that reasonable skill and care is judged against the standards of the profession. They say they wouldn't generally expect a trader to check every single possible configuration on the consumer's device before providing digital content, which I'm sure will be a relief. And what's reasonable will depend on the particular circumstances. So they give the example that if you're a trader and you're sending out an emergency update to respond to a security threat, the standard of care is considerably lower than if you're doing a planned routine update to fix bugs. So if the consumer can bring a claim under that, against you under this provision, then what you have to do is either repair the damage to their device and the digital content, or just pay them some money, compensate them. And it's you, the trader, who chooses between those two remedies. So if you are involved in giving out free digital content, you need to make sure that you've got records in place showing reasonable skill and care in the way it's been created and distributed. And also, some comments from BIS suggest that you might be able to reduce your liability by providing very easy to understand instructions for installation and use, so that if the consumer doesn't follow, then you're in a slightly better position. So, yeah.
All right, excellent. Okay, so we've reached the end of the scheduled questions we have, but you're not quite off the hook yet, Rachel. We do have some live questions submitted, so I'm going to put you on the spot.
Okay.
And the first question in is, can a sole trader ever be a consumer under the Act?
A good question. I think we have had quite a few questions from subscribers asking the same question, actually. And the position is that the definition of consumer, under the old legislation, there were various different definitions, but now we've moved to a sort of unified definition of consumer across all consumer protection legislation. And it is that a consumer is an individual acting for purposes wholly or mainly outside their trade, business, caste, or profession. So it has to be an individual. It can't be a corporate. It can't be any kind of company or a limited liability partnership. That's the individual part. And so a sole trader is an individual, or a partner on their own is an individual. So in theory, they can contract as a consumer. But whether they did so will depend on whether they're buying for purposes which were wholly out or mainly outside their profession. And this wholly or mainly element was introduced by the UK government. It's not in EU legislation. It's the Law Commission decided that they wanted to give a bit more protection to people who are buying things for consumer purposes but occasionally use them for work. And some of the examples that have been given in the guidance are things like if you buy a mobile phone but you make occasional work calls, you'll still be treated as a consumer. Or if you buy a laptop mainly for games but you send work emails. But I think from memory, one of the provisions, the examples they give is that if you're a sole trader and you buy a printer and you use it 95% of the time for work and 5% of the time for your kids' homework or whatever, you're not treated as a consumer. You're buying in the course of your business. You don't get the consumer protections. But actually, we've been doing our email for this week, and we're covering a consultation which BIS launched yesterday on possible additional protections for micro businesses. And the micro businesses up to 9 employees, and what they're consulting on is whether these micro businesses, which would include sole traders, should be entitled to more protection. But interestingly, they're not saying, oh, well, we'll just treat them as consumers. They're looking at things like having statutory guidance for other businesses on how to deal with micro businesses. I think they're suggesting it would deal with things like simplifying the contracting situation and guidance on how to deal with disputes. And the other thing they're asking about is whether there should be information obligations on traders dealing with micro businesses similar to ones under the consumer contracts regulations. So that's all the stuff about telling them about the main characteristics of the products and the price and getting all that information across to them before they form the contract and making it a term of the contract. So it'll be interesting to see where that all goes to, because this consulted last year on protecting small businesses. But I think from a lawyer's perspective, I think obviously it's good in the sort of public policy sense that it will introduce another layer of complication, because you'll then be having to sort of think about your terms and conditions when you're dealing with consumers, when you're dealing with businesses, when you're dealing with small businesses, and potentially in a different way when you're dealing with micro businesses. So it's all could potentially get quite complicated.
Yeah, it sounds like it. Okay, so next question lined up, again from our live listeners. 2, are retailers required to inform customers of their statutory rights under the CRA?
There's no general requirement for the trader to set out the consumer's statutory rights. I think that position hasn't changed. All their remedies, if the products are defective or misdescribed. But there are some requirements to refer to their statutory rights in respect of goods, not to set them out, but to sort of refer to them. So under the consumer contract regulations, it's a requirement that you have to have somewhere, basically, usually in the terms and conditions, a statement that it's your legal duty to provide goods in conformance with the contract. And then the other thing to remember is that if you're giving the consumer a guarantee, you have to say that the guarantee doesn't affect the consumer's statutory rights, which is wording that everyone's familiar with. But the CMA guidance deals with that, actually, and it says that they don't like the term statutory rights because they describe it as archaic, and they say no one understands it. And they also say that they, ideally, instead of just saying that, you should indicate what kind of protection the consumers have. And in our standard terms and conditions, we have got a sort of, I suppose, optional statement, which we've kind of taken from trading standards to point of sale guidance, which is just, I suppose, it's designed to be shown in shops where it says, you know, if your goods are defective, these are your rights. We've suggested a sort of an adaptation of that for use in the contract, because it does have some benefits setting that out, because it's clear then that you're meeting that requirement to refer to your statutory rights in the context of the guarantee. And also, under the consumer protection from unfair trading regulations, it's illegal to sort of suggest that the remedies that you're giving to the consumer, the contractual remedies, are a distinctive feature of their. So you can't try and suggest that their sort of statutory rights are somehow a distinctive feature of what you're offering. You need to make it clear that you need to make it clear that the statutory rights are the statutory rights, and what you're offering is something different. You can't suggest that you're great because you're offering to replace defective products if they're entitled to do that anyway under law. So I think by clearly setting out what the statutory rights are, you're not going to fall into that trap.
Excellent. Thanks, Rachel. Doing a great job, by the way. I think we've got time just to squeeze in a couple more questions. Next question I've got lined up is, what are the implications of the Act for online marketplaces?
Okay. So an online marketplace, you've got your trader sort of contracting through, I suppose there's a lot of different models, aren't there? But generally you've got the trader and then they're selling through, they're kind of standing behind an online marketplace, which is dealing with the sales on their behalf. I think the key thing is that the Consumer Rights Act does clarify that where a trader is acting to somebody else, they're still responsible for complying with the Act. I think that was less clear in the old legislation. I'm not sure that the position's really changed. I think the issue for the trader is ensuring that the marketplace that they're using meets all the trader's responsibilities around dealing with the customer. For example, presenting the pre-contract information under the consumer contracts regulations, especially when you're dealing online. There are very strict rules about when certain information must be given to the consumer. Some, for example, things around the delivery have to be told them before they start the ordering process. Some information has to be given immediately before the contract's formed, before the consumer places the order, I think. So the concern for a trader who's dealing through a marketplace is to ensure that they're meeting that marketplace is in a position to meet all those requirements. I think the position is even more complicated if you're selling digital content and you as the owner want to introduce some license conditions, have a direct license with the end user. Somehow you'd need to build into the contracting process a point at which the consumer accepts those particular terms and conditions, but ideally. So I think it's all a question of the marketplace and the trader working together to ensure that everything works out and that all the boxes are ticked.
Okay, excellent. We've got time to squeeze in one last question for you.
Okay.
Ready?
Yeah. Okay.
So, do the CRA quality rights apply to bespoke and discounted goods?
Luckily, that's an easy one.
Oh, superb.
Because there are no exceptions for those type of goods. There's no special provisions around. Well, there is a sort of a clarification in the Consumer Rights Act, because previously it wasn't clear that created goods were going to be, so for example, a bespoke suit was going to be treated as goods rather than the end product of services. But that's now being clarified specifically in the Act. So yeah, all the quality standards apply to bespoke goods. But they also, the other thing actually to mention is that there's a new provision which says that if the consumers sort of contributed materials which cause non-conformities in the goods, so if you, in this bespoke goods, you supplied something, some tartan lining for your suit, and you've given that, and that causes the problem, then the consumer doesn't have a remedy for problems caused by the tartan lining. That's something to bear in mind. So in the context of discounted goods, I think the position is effectively the same as it was before. The satisfactory quality is still the issue, but you can take into account the price that they've paid. So obviously you paid less for discounted goods, so the standards might be slightly lower. And also, I suppose importantly for the trader, if they draw the defect to the consumer's attention, then they're off the hook. So that's why you see all those sort of labels on goods saying that as long as you've made it clear to the consumer, or if the consumer's had a chance to examine the goods, and that's the other exception, if they've had a chance to look at them properly and they should have spotted the defect, then you're not responsible for that. So there are some sort of finer points to it, but yeah, basically the standards apply.
Okay. Super, thank you. Well, we've reached the end.
Okay.
And we don't have any, you'll be pleased to know, you can rest now. We don't have any time for any more questions. But big thank you to Rachel for your insightful and in-depth answers to the questions. Did a sterling job. As I mentioned earlier, if you have sent in any questions that we didn't get to cover off during this period, then we will follow up with you individually. So rest assured you will receive an answer to your question. And that's it from us, really. Thank you very much for listening, and enjoy the rest of your day. Goodbye.
Goodbye. Thank you.